The Senate Judiciary Committee examined the Foreign Intelligence Surveillance Act, known as FISA, and the reauthorization of Section 702 of the law. Section 702 allows intelligence agencies to access communications of foreign nationals outside of the U.S. Witnesses included officials from the FBI, the Justice Department, the Office of the Director of National Intelligence, and the National Security Agency. This is 2 hours and 35 minutes.
Important issue that we have before us. Today's public hearing will be followed by a classified briefing tomorrow afternoon. This committee last held an oversight hearing on Section 702 in May of 2016. Since then, the drumbeat of terror attacks against the United States and other countries, particularly our allies, has continued. A month after our hearing, a terrorist attacked an Orlando nightclub, killing 50 and wounding 53. That same month, a terrorist detonated pipe bombs in New Jersey and New York, injuring about 30. Last month, Great Britain suffered its worst terror attack in over a decade. A suicide bomber killed 22 and seriously injured many more at a concert in Manchester. Many of the dead and wounded, as you know, were children and very young people. These attacks underscore that the first responsibility of government is to ensure that those who protect us every day have the tools to keep us safe. And when I said government, I should have said of the United States government under our Constitution. These tools must adapt to the technological landscape and the evolving security threats that we face. But at the same time, of course, the rights and liberties enshrined in the Constitution are fixed. They require our constant vigilance to maintain those. Section 702 of FISA Amendments Act, which provides the government the authority to collect the electronic communications of foreigners located outside of the United States with the compelled assistance of American companies, sits at the intersection of these responsibilities. Under Section 702, it's against the law to target anyone in the United States or any American citizen, wherever that citizen is on this globe. The statute also prohibits reverse targeting. That term means targeting somebody outside the United States for the purpose of targeting somebody inside of the country. Under the statute, the FISA court must approve targeting and minimization procedures to ensure that only appropriate individuals are subject to this surveillance. These procedures also limit the handling and use of any communications so collected, and implementation of the statute is overseen by all three branches of the government, including the appropriate inspectors general. After much debate and after much discussion, this law was passed by Congress and signed by President Bush in 2008. The Obama administration requested that it be reauthorized without any changes, and Congress did just that in 2012. Now, President Trump's administration is making the same request. From all accounts, Section 702 has proven highly valuable in helping protect the United States. The Privacy and Civil Liberties Oversight Board found unequivocally that Section 702, quote, has helped the United States learn more about the membership, the leadership structure, priorities, tactics, and plans of international terrorist organizations and has enabled the discovery of previously unknown terrorist operatives, as well as the locations and movements of suspects already known to the government. End of the quote from that Oversight Board. The board concluded that Section 02, quote, has led to the discovery of previously unknown terrorist plots directed against the United States and foreign countries, enabling the disruption of these plots, end of quote. Moreover, the board, the FISA court, and other federal courts have found the implementation of Section 702 lawful and consistent with the Fourth Amendment. In addition, the board proposed a number of recommendations in its report to help improve the privacy and the civil liberties protections of Section 702 program. According to the board's most recent assessment report, all of its recommendations have been implemented in full or in part, or the relative agency has taken significant steps towards adopting these recommendations. In 2016, a Heritage Foundation report concluded that 702 is a, quote, critical and invaluable tool for American intelligence professionals and officials, so vital to America's national security that Congress should reauthorize Section 702 in its current form, end of quote. But, as is always the case with policy issues here in the Congress, particularly between the freedom of the American people and our national security concerns, we do have questions and concerns persist for some about Section 702's effect on these civil liberties. Some of these concerns relate to communications incidentally collected when it turns out that a targeted foreigner is in contact with somebody inside the United States or with an American. But of course, there is often no way to know who a surveillance target may be in contact with beforehand. That's in part why they're under surveillance in the first place. And these are situations where the program can be highly valuable by letting our government know if a foreign terrorist plot might reach our shores. Still, the unknown scope of this incidental collection is concerning to many. We ought to understand that. Some are also concerned with the way in which the FBI is permitted to search already collected 702 material. However, it was precisely this kind of information sharing that was recommended by both the 9/11 Commission and the Webster Commission that convened after the Fort Hood attack. Law enforcement needs to be able to connect the dots and do that to protect the American people. In addition, the recent FISA court opinion that admonished the executive branch for its failure to comply with the minimization procedures in some ways ought to be and is highly concerning as well. Finally, there have been allegations that intelligence reports have been unmasked for partisan political purposes. Although these allegations haven't been directed at Section 702 specifically, they're highly troubling. And leaks of classified information that damage our national security seem to continue unabated. I understand that no internal or external review to date has found any evidence of intentional abuse of Section 702 for any reason whatsoever. Nonetheless, it is important that Congress make sure that it hasn't been so abused. And it's equally important that we ensure that the Justice Department has all the tools that it needs to prosecute leaks of classified information. So taking all these things into consideration, is one of the reasons and the main purpose for having this, but national security has to be at the top of the list. And so we welcome our witnesses and look forward to their testimony today. And don't forget the classified briefing tomorrow. Senator Feinstein.
Thanks very much, Mr. Chairman, and I too welcome our witnesses. I know they're rather grim-faced, but I hope there will be a smile or two forthcoming. I want to say thank you for holding this hearing, and let me begin by saying I fully support reauthorization of the FISA Amendments Act, including Section 702. Earlier this month, the Intelligence Committee, of which I am a longtime member, along with Senator Cornyn of this committee, held a hearing on Section 702 of FISA. This will likely mean that intelligence will be passing a bill very shortly. In fact, Senator Cotton and a number of other Republican senators on the Intelligence Committee have offered a bill which would permanently authorize the FISA Amendments Act, including Section 702, without the 5-year sunset. I would note, however, that Senator Cotton's bill was referred to this committee, the Judiciary Committee, and there's a reason, and that is because this committee has the jurisdiction over both FISA and 702, particularly given the impact on Americans' communications and privacy. So I think it's important that our committee get to work quickly on reauthorization of 702, which, as we know, is a very critical program in the collection of valid intelligence. Let me state at the outset that I believe any reauthorization should include a sunset provision, and without it, it will not have my support. Congress has an important oversight role to play in these measures. Society changes, the world changes, technology and communications change, and a sunset allows us to review and revise such as may be necessary due to technology changes as well as other changes that happen at such a rapid pace. Currently, the government is required to obtain approval from the FISA court every year before continuing its content collection under 702. Congress should have the same ability to review and evaluate this program on a periodic basis. A sunset provision allows us to do just that. As a matter of fact, it's 5 years now. I would urge that it be 6 years because that takes it outside of an election year. Let me restate that I fully support the 702 program. I believe it's a vital counterterrorism tool. The Intelligence Committee under both Democratic and Republican administrations has consistently stated that the program produces critical foreign information to protect the nation against international terror and other threats. The Privacy and Civil Liberties Oversight Board, which we call the P-Club Board, has conducted extensive independent review of the 702 program and concluded, and I quote, "The information the program collects has been valuable and effective in protecting the nation's security and producing useful foreign intelligence." The Section 702 program also includes a number of safeguards to ensure the protection of privacy and civil liberties. Under current law, for example, Section 702 authorizes the targeted collection of the content of internet and phone communications only, and I underline that, of foreigners who are located outside of the United States, and only underlined for the purpose of gathering foreign intelligence information. Moreover, although there have been some compliance incidents over the years, there has never been a finding of intentional abuse of 702 authorities, never. In fact, the Privacy and Civil Liberties Oversight Board, P-Club, found, and I quote, no trace of any such illegitimate activity associated with the program or any attempt to intentionally circumvent legal limits, end quote. In addition, the program is subject to extensive oversight by the Foreign Intelligence Surveillance Court, the FISA court, the relevant inspectors general, and dedicated internal oversight personnel at the Justice Department and the ODNI. Another reform we might take a look at is requiring the FISA court to appoint an outside counsel, known as an amicus, each time the government seeks court approval of its annual certification that happens every year to continue the Section 702 program. This was actually done, I think, on the last certification, and I think it's helpful in reassuring people that there is an independent individual in the court reviewing these matters. Mr. Chairman, I want to thank you once again for calling this hearing, particularly since we have the jurisdiction to play this role. And I hope we can get our act together and take a look at the bill that is here that Senator Cotton has introduced, and that we can move it, but with a sunset clause. So I want to thank the witnesses for being here today, and thank you, Mr. Chairman.
In regard to your question on process, you and I have not talked about that process yet, but our staffs at the highest level have been talking about that, and we'll wait until they report to us.
Well, I assume they're not going to change our jurisdiction, because we have jurisdiction.
Yeah.
Okay, thank you.
Our first panel, I'm going to introduce each of you, and then you'll speak my left to my right, and then we'll ask questions. So we'll have 5-minute rounds of questions. Bradley Brooker serves as acting general counsel and designated agency ethics official for the Office of the Director of National Intelligence, and previously worked as an attorney at an international law firm. Mr. Brooker is a graduate of Arizona State University and American University of Washington College of Law. Stuart Evans serves as Deputy Assistant Attorney General for Intelligence at the United States Department of Justice. He previously served in a number of career positions within the Department of Justice's National Security Division, including as both Chief and Deputy Chief of the Office of Intelligence Counterterrorism Unit. He obtained his bachelor's degree from the University of Pennsylvania and his law degree from Columbia University. Carl Gaddis serves as the Executive Assistant Director of the National Security Branch at the Federal Bureau of Investigation. He leads the operations and intelligence efforts in national security matters, ranging from terrorism to espionage to weapons of mass destruction. In 2014, he was appointed Special Agent in charge of the Washington Field Office's Counterterrorism Program, and most recently served as Assistant Director of Counterterrorism Division. Mr. Gaddis earned a Bachelor of Arts degree from Duke University and a Juris Doctorate from Washington University. Paul Morris is the Deputy General Counsel for Operations at NSA. He oversees the agency's practice groups for legislation, intelligence law, and information assurance and cybersecurity. Mr. Morris received his bachelor degree from the University of Maryland and his law degree from George Washington University. Would you please start, Mr. Brooker? And by the way, if you have longer statements, they'll be put in the record. I never wrap the gavel at exactly 5 minutes, but when the red light comes on, try to summarize as best you can to finish shortly thereafter. Proceed.
Great. Chairman Grassley, Ranking Member Feinstein, members of the committee, we all want to thank you for holding this hearing and having us here today together with my colleagues from DOJ, NSA, and FBI. As you know, intelligence collection under Section 702 has produced and continues to produce significant intelligence that is vital to protect the nation against international threats, whether they be counterterrorism, weapons proliferation, or cyber threats. At the same time, it provides incredibly strong protections for the privacy and civil liberties of our citizens. To that end, permanent reauthorization of the FISA Amendments Act without further amendment is the intelligence community's top legislative priority this year. I want to begin today by giving a very recently declassified example of the impact of Section 702. Before rising through the ranks to become at one point the second in command of the self-proclaimed ISIS, Haji Imam was a high school teacher in Iman. His transformation to a terrorist caused the United States government to offer a $7 million reward for information leading to him. It also made him a leading focus of NSA's counterterrorism efforts. NSA, along with its IC partners, spent over 2 years looking for him. This search was ultimately successful primarily because of Section 702. Indeed, based almost exclusively on intelligence activities under Section 702, NSA collected a significant body of foreign intelligence about the activities of Haji Imam and his associates. Beginning with non-Section 702 collection, NSA learned of an individual closely associated with him. NSA then used collection permitted and authorized under Section 702 to collect intelligence on the close associates, which allowed NSA to develop a robust body of knowledge concerning the personal network of both Haji Imam and his close associates. Over 2 years, using Section 702 collection and in close collaboration with our IC partners, NSA produced more intelligence on Haji Imam's associates, including their location. NSA and its tactical partners then combined this information with other intelligence assets to identify the reclusive Haji Imam and track his movements. Ultimately, this collaboration enabled U.S. forces to attempt an apprehension of him and his 2 associates on March 24th of last year. During the attempted apprehension operations, shots were fired at U.S. forces from his location. U.S. forces in turn returned fire, killing Haji Imam and his other associates at that location. Subsequent Section 702 collection confirmed his death. This is just one example. And although many of the successes enabled by Section 702 are highly classified, and we'd like to discuss them tomorrow in more detail at the classified session, the purpose of the authority is to give the IC and give the U.S. government the upper hand in trying to avert attacks against our citizens and our allies before they transpire. At the same time, Section 702 provides strong protections for the privacy and civil liberties of our citizens. As Mr. Evans will discuss both the legal framework and our oversight efforts, I do want to briefly highlight 2 things. First, Section 702 has several important legal restrictions that protect the constitutional and privacy rights of our citizens. And second, the government Section 702 program is subject to rigorous and frequent oversight by all 3 branches of government. And I want to stress what both the chair and ranking member stressed earlier. We are particularly proud of our oversight records, and the audits conducted by both ODNI and DOJ have routinely shown extremely low error rates, and that we have not once found an intentional violation of the law. There have been mistakes, but a system with 0 compliance incidents, frankly, is a broken compliance system because humans make mistakes. As a recent example of the oversight process at work, and as Mr. Morris will discuss, NSA identified a compliance incident involving queries of U.S. persons in the Section 2 acquired upstream collection. In short, the compliance incident was identified, it was reported, the interagency worked together to find a solution, proposed a new set of procedures to the FISC, and we've moved forward. Before I conclude, I do want to speak about one issue that I know has been subject of much public discussion. There's been a push from both Congress and the advocacy community for NSA to attempt to count the number of United States persons whose communications are incidentally acquired under Section 702 collection. NSA has made significant efforts to devise a counting strategy that would be accurate and that would respond to the question asked. Unfortunately, we were unable to develop an accurate, meaningful, and cost-effective methodology. I want to be clear here. To determine if communicants are U.S. persons, NSA would be required to conduct significant additional research trying to determine whether individuals who may be of no foreign intelligence interest at all are U.S. persons. This raises 2 principal concerns. First, we would be asking trained NSA analysts to conduct intense identity verification research on potential U.S. persons who are not a target of investigation. From a privacy and civil liberties perspective, we find this unpalatable. Second, those scores of analysts would have to be shifted from key intelligence focus areas. The DNI has made clear he cannot justify such a diversion of critical resources, particularly at a time when we face such a diversity of serious threats. And even if we decided the intrusions were justified, and even if we had unlimited staff to tackle this problem, we still do not believe it's possible to come up with an accurate, measurable result, because it would be impossible to determine the identity of every communicant on an email, leaving us with a significant number of unknown identities, even after substantial research. With that, I'd like to turn it over to Mr. Evans.
Mr. Evans.
Chairman Grassley, Ranking Member Feinstein, members of the committee, thank you for the opportunity to be here today and to speak with you about this vital national security program. With Mr. Brooker's introduction as a backdrop, we want to turn briefly to a discussion of why it became necessary in 2008 for Congress to enact Section 702. The Foreign Intelligence Surveillance Act, or FISA, was first passed in 1978, creating a way for the government to obtain individualized, probable cause-based court orders for electronic surveillance of suspected spies, terrorists, and foreign officials located inside the United States. But when originally enacting FISA, Congress largely carved out of FISA's regime surveillance directed at foreigners located abroad. And the reason for that, of course, is that foreigners located abroad are not protected by the Fourth Amendment, while individuals located inside the United States are. Congress accomplished this distinction in large part by defining electronic surveillance based on the technology in existence at the time. In the early 1970s, overseas communications were predominantly carried by satellite. FISA, as originally passed in 1978, did not require a court order for the collection of those overseas satellite communications. So to give you an example, if in 1980, NSA intercepted a satellite communication of a foreign terrorist abroad, no court order was required under FISA to intercept that communication. However, by 2008, technology had changed considerably. First, US-based email services were now being used by people all over the world. And second, the overseas communications that in the 1970s were carried by satellite were now more commonly carried by fiber optic cables. So to continue my earlier example, if in 2008 that same foreign terrorist was communicating by using a US-based email service, a traditional FISA court order was required to compel a US-based company to assist in that collection. And under traditional FISA, a court order can only be obtained based on a showing of probable cause that the target of the surveillance is a foreign power or an agent of a foreign power. This is a difficult, time-consuming, and resource-intensive process. In sum, because of changes in technology, before Section 702 was enacted, the same resource-intensive legal process was being used to conduct surveillance of foreigners located abroad who are not protected by the Fourth Amendment, as was being used with respect to individuals located inside the United States who are protected by the Fourth Amendment. By enacting Section 702 in 2008 and renewing it in 2012, both times with open public debate and significant bipartisan support, Congress corrected this anomaly and restored the balance of protections established by the original FISA statute. Although I won't go into extensive detail in my remarks regarding the legal framework for Section 702, I will note a few key items. First, the statute requires certifications from the Attorney General and the Director of National Intelligence authorizing the types of foreign intelligence information that the intelligence community may acquire under this authority. Second, the statute requires what are called targeting procedures and minimization procedures. The targeting procedures and the Attorney General guidelines set forth the rules by which the intelligence community ensures that only foreign persons abroad are targeted for collection. And the minimization procedures protect US person information that is incidentally acquired from the targeting of the foreigners abroad. And finally, the FISA court reviews each Section 702 certification to make sure that the government's program is consistent with both the statute and the Fourth Amendment. We have declassified and publicly released lightly redacted versions of all of these documents, including the most recent FISC opinion, to ensure the public has a good understanding of how we use this authority. And importantly, the government's Section 702 program is subject to rigorous and frequent oversight by all three branches of government. The first line of oversight and compliance is within the agencies themselves. The vast majority of incidents of noncompliance that are reported to DOJ and ODNI are self-reported by the participating agencies. In addition, DOJ and ODNI conduct regular reviews focusing on compliance with targeting procedures, as well as on the querying of collected data and on dissemination of information under the minimization procedures. Further, we have regular engagements with and extensive reporting to Congress about Section 702. For example, the Judiciary and Intelligence Committees receive relevant orders and opinions of the FISA court and associated pleadings, and descriptions and analyses of every compliance incident. And importantly, the FISA court itself regularly checks our work, both through the annual recertification process and through regular interactions regarding particular instances of noncompliance. The members of the FISA court are federal district court judges appointed by the Chief Justice to serve on the FISC in addition to their regular district court responsibilities. As we've now seen from numerous declassified FISA court opinions, their review of the government's compliance with Section 702 is exacting and thorough. As Mr. Brooker indicated, reviews of the program conducted by DOJ and ODNI have shown that error rates are extremely low, consistently less than 1%, and we have never found an intentional violation in the program. And as the chair and ranking member indicated, this isn't just our own conclusion. In 2014, the Independent Privacy and Civil Liberties Oversight Board confirmed these findings. The board unanimously stated, and I quote, that it was impressed with the rigor of the government's efforts to ensure that it acquires only those communications it is authorized to collect and that it targets only those persons it is authorized to target. We do find errors in compliance incidents, but when that happens, we ensure that they are reported and corrected. And with that background on the program, I'll turn to my colleague from the FBI who will discuss the FBI's implementation of Section 702.
Mr. Gaddis.
Mr. Chairman, Ranking Member, members of the committee, good morning and thank you for this opportunity to discuss 702. Section 702 is an extremely valuable and critical investigative tool for the FBI. Every FBI division conducting national security investigations benefits from information collected pursuant to Section 702. That's whether that information is shared by the NSA as a tip or whether the information is collected on a target relevant to an FBI investigation. Let me share with you an example which I, exercising my discretion as an original classification authority, have determined can be declassified to help the American people better understand the value of Section 702, especially with respect to its fight with ISIS. In October 2013, the FBI started investigating Sean Parson, a foreign person from Trinidad and Tobago. This was done after he posted comments online expressing his desire to commit an attack against Western interests. As in any investigation, we used a range of investigative tools and techniques, including Section 702 in the investigation of Parson. We did this in an effort to detect any attack planning that was underway and assess the extent of his influence. In November 2014, Parson traveled from Trinidad and Tobago to Syria and became increasingly vocal online. The FBI's investigation, including information collected pursuant to Section 702, revealed that Parson was a trusted member of a prolific ISIS network. Parson was a key player in this network. The network used the internet and, more importantly, social media to distribute prolific amounts of English language terrorist propaganda. They encouraged their online followers to carry out attacks in Western Europe and the United States. They used social media daily. They used those postings daily and directed communications with people rapid fire and spread their message encouraging people to attack. Parson was a native English speaker, and he even appeared in an ISIS recruiting video. This ISIS network identified American military men and women and posted their names and addresses online. They instructed their online followers to, quote, kill them in their own lands, behead them in their own homes, stab them to death as they walk their streets thinking they are safe, unquote. Parson personally encouraged his followers to attack U.S. police officers, U.S. military bases located in Colorado, Ohio, and soft targets in New York City, Chicago, and Los Angeles. Information obtained through Section 702 coverage not only revealed Parson's persistent terrorist propaganda, but it also was instrumental in identifying additional members of Parson's network. The FBI shared this information about Parson's network with the rest of the U.S. intelligence community. We also shared it with trusted international partners. Sharing Parsons' contacts with our international partners was critical as it led to the identification of additional ISIS facilitators and supporters in those countries, and it potentially prevented attacks in those countries as well. Parsons was eventually killed in Syria in September 2015. Let me talk next about the FBI's practice in querying 702 collection. With regard to that collection, it's important to remember that the FBI receives a small fraction of the total collection that NSA acquires under this program. In fact, the FBI only receives a small percentage of NSA's downstream collection and none of NSA's upstream collection. The reason for this is that the FBI can only request and receive Section 702 collection if the selector, that is an email address or social media handle, for example, is relevant to a pending full investigation. The FBI cannot receive Section 702 collection during either a preliminary inquiry or an assessment. As a result, although the FBI conducts significantly more U.S. person queries than NSA, those queries are run against a small fraction of the total 702 collection that is acquired by the U.S. government. In other words, when the FBI runs a U.S. person identifier through our database, that query is run against only FBI's 702 collection that's obtained during FBI full investigations and not the total collection maintained by NSA. I'd like to discuss the value that 702 U.S. person queries can help play in helping the FBI combat the threat from ISIS. The intelligence community and the FBI utilize Section 702 to acquire communications of ISIS members who are non-U.S. persons located overseas. After those communications are collected, they're retained in our database and are available for authorized FBI agents and analysts to subsequently query, just like any other information we've gathered over the course of previous investigations. Later, when a tip or lead suggests that a U.S. person located here may pose a threat, one of the best investigative steps is to search existing collection to determine what kind of threat we're dealing with. This is what helps us connect the dots. Finally, I'm aware that some critics of the 702 collection program have suggested that the FBI should obtain a warrant before querying a U.S. person identifier against our 702 collection. Imposing a warrant requirement would severely hamper our operations by creating an unnecessary barrier between the FBI and threat information that is already in our possession. This is in direct contradiction to the recommendations of both the 9/11 and Webster commissions. I'm happy to answer any further questions you may have about this particular subject during the course of this hearing. Thank you at this point for allowing me to make these remarks. And now I'll turn it over to Mr. Morris from the NSA.
I think we will on this.
Can you take a survey?
Yes.
Mr. Morris.
Mr. Chairman, Ranking Member, and members of the committee, thank you for this opportunity to speak with you today about the FISA Amendments Act and specifically Section 702, which, as you've heard, is a critical national security authority. As you know, Section 702 may only be used by the intelligence community to target foreign persons located outside the United States. My name is Paul Morris. I am NSA's Deputy General Counsel for Operations. I've been with the intelligence community for almost 30 years and have been involved in the NSA's implementation of Section 702 since the law was first passed in 2008. Every day I have the opportunity to see the importance of Section 702 to the United States national security. I also participate in the robust oversight regime that governs Section 702. It is those two subjects that I would like to speak with you about briefly today. Section 702 is one of the most valuable operational authorities the intelligence community has. It is responsible for thousands of intelligence reports per year, and here are three brief examples of Section 702's value. NSA's analysis of Section 702 collection discovered the communications of a member of a major terrorist group in the Middle East who is communicating with an extremist in Europe who is sharing ideas on how to commit a terrorist attack. Specifically, NSA discovered communications where the individual in Europe was discussing the purchase of material to build a suicide belt. NSA shared this critical information with European partners in an attempt to disrupt further attacks against U.S. and allied interests. We also use Section 702 to learn about sanctions evasion activity by a sanctions-restricted country. Section 702 collection provided information that was key to interdicting shipments of prohibited goods by the target country. The usefulness of Section 702 goes beyond finding terrorists and stopping shipments of sanctioned goods. Today, I can share for the first time publicly an example of how Section 702 protects the American public when they use their smartphones. In 2016, thanks in part to NSA's Section 702 collection, the agency was able to obtain intelligence on a foreign government's state-sponsored phone application that impacted cybersecurity and was not publicly known. Because of this discovery, the app was ultimately removed from the various phone application marketplaces. This last example illustrates how all of us are better off because of Section 702. The other aspect of Section 702 that I would like to discuss today is the robust internal NSA oversight that governs the program. The oversight begins with the initial decision to nominate a foreign person for targeting. An NSA analyst must conduct research to determine whether the proposed target is a foreign person located outside the United States who possesses or is likely to communicate foreign intelligence information that is relevant to a certification that has been executed by the Attorney General and the Director of National Intelligence. After the analyst makes that initial determination, 2 other NSA employees who are also trained in the proper targeting under Section 702 must review the proposed targeting all before the targeting occurs. Finally, a copy of the NSA's targeting sheet will be provided to the Department of Justice and ODNI for external review. In addition to the targeting process, NSA's Office of General Counsel works hand in hand with analysts and operators at every stage of the process, from targeting to reporting to ensure compliance with the law and the court-approved procedures that govern our activities. We also have a separate compliance group which regularly performs reviews of NSA's personnel's access to and use of 702 information. The compliance group also examines 702 activities on a more programmatic basis to look for ways to further improve the agency's compliance posture. Finally, we have an Office of Inspector General that possesses broad and independent authority to review 702 activities for compliance with the law and our procedures. This leads me to one very important and recent Inspector General finding that Mr. Brooker mentioned. NSA's Inspector General identified a compliance matter that ultimately led to our announcement in April of the suspension of About's collection. The committee will recall that About's communications, while operationally valuable, come with heightened U.S. person privacy concerns. We terminated About's collection after a comprehensive review weighed the operational loss against inspected improvements in our ability to comply with our court-approved procedures. Ultimately, we concluded we could stop collecting About's communications, but retain the aspect of Section 702 upstream collection that is currently providing the most current operational value. In short, NSA expends significant resources examining its use of Section 702 to ensure that the program is both operationally effective and is also protective of Americans' privacy. Thank you, and I look forward to your questions.
As I indicated, we'll have 5-minute rounds. Mr. Evans, before I ask your question, I'll give this background because some people have suggested that the government should have to get judicial approval or even a warrant before searching lawfully collected Section 702 information using U.S. person information such as name, phone number, or email address, particularly in non-national security investigations. So what is the administration's view about whether there is any legal or constitutional reason why this is necessary? And what would be the impact if Congress decided to add a warrant requirement before agents could conduct these database checks?
Thank you, Mr. Chairman. The executive branch has outlined in several filings and court pleadings that are public what our position on this is as a legal matter, which is that, legally speaking, under both the statute and the Fourth Amendment to the Constitution, a warrant is not required to conduct these so-called queries. And I think the first thing to understanding why that's the case is understanding what a query is when we talk about a U.S. person query of the Section 702 data. We are not acquiring any new information. We are not conducting any additional surveillance. It's simply a targeted review of information already in our possession that we've gathered through the surveillance previously of a foreigner located overseas. And that matters for Fourth Amendment purposes because whether a warrant is required under the Fourth Amendment matters on how you acquire the information. And here, all of the information that we're talking about was acquired through the targeting of foreigners located abroad and collected for foreign intelligence purposes. And every court to consider this issue, and that's not just the FISA court, that's also federal district courts, have reached the conclusion that as a legal matter, a warrant isn't required to collect that information in the first place, and therefore isn't required to review it after we've subsequently collected it. As a policy matter, imposing a warrant requirement would effectively, as a practical matter, prohibit these queries from being done for a wide range of reasons. First, probable cause is a very high threshold, and a query is a baseline investigative technique that is used in the early stages of an investigation to rule someone in, rule someone out, try to connect the dots. At that stage of an investigation, it's often the case that probable cause won't exist. So that's one reason it's problematic. A second reason is time and volume. Because of the speed with which these queries need to be run to try to connect the dots and the volume which they need to be run, requiring a court order for them would effectively grind the entire FISA process to a halt.
For Mr. Gaddis and Mr. Morris, before I ask you your question, in a recently declassified April 2017 decision, the FISA court revealed that it was concerned about an institutional, and these are their words, lack of candor on NSA's part concerning its reporting and compliance with Section 702 minimization procedures. In addition, the court seemed to have very harsh words for the FBI, saying, and I quote, that the court was concerned about the FBI's apparent disregard of minimization rules and whether the FBI may be engaging in disclosure of raw Section 702 information that have not been reported, end of quote. So, question, I think it's really important, satisfying some people, what are the NSA and the FBI doing to address these specific concerns of the court? And this will have to be my last question, so both of you answer that if you would.
Thank you, Mr. Chairman. I'll go first since the first quote you read concerned NSA. Yeah. We take our duty of candor to the Foreign Intelligence Surveillance Court as well as to all our overseers very, very seriously. Obviously, I cannot speak for Judge Collier, what she meant specifically when she wrote that in the opinion, but my understanding factually of what happened was as follows. We had initially identified that we had made some errors of U.S. person queries against our upstream collection. So since 2011, our minimization procedures had prohibited outright any U.S. person queries running against upstream 702 collection, largely because of abouts communications. We had reported the initial query errors, I believe it was in 2015 when we made our initial report, but our Office of Inspector General as well as our compliance group had separate reviews ongoing to try to determine the scope and scale of the problem. So during the course of filing the renewal for the 702 certifications that were pending, the court held a hearing in early October 2016 when it asked about various compliance matters to include the improper queries, and we reported on the status of those investigations as we knew them to be at that time. On about 2 or 3 weeks later, the Office of Inspector General completed its follow-up review of the U.S. person query and discovered that the scope of the problem was larger than we'd originally reported. As soon as we identified that the problem was larger than we thought it was, we notified the Justice Department and the ODNI. In turn, the court was notified, and the court held a hearing on October 26th to go into further detail about the problem, and that ultimately led to a couple of extensions of the certifications, and ultimately our decision to terminate abouts collection in order to remedy the compliance problem. So my sense is that the institutional lack of candor that the court was referring to was really frustration that when we had the hearing on October 6th, we did not know the full scope and scale of the problem, until later, which was reported again roughly October 24th, which led to a hearing on October 26th, which was the day before the court was supposed to rule on extending the certification. So that was how I take it. But certainly the agency believes it's absolutely essential to have full transparency with our overseers in terms of how we're using the authority, how it works, and to report when we make errors.
Mr. Gaddis.
Thank you, Senator. Senator, the FBI takes very seriously its reputation for candor, whether it's before this committee or before the FISA court. Additionally, the FBI welcomes the oversight by the FISA court. We welcome the oversight by this and our other oversight committees, the Inspector General and DOJ and the DNI. It's absolutely critical to what we do to make sure that we have other eyes ensuring that we are compliant with the laws and with the Constitution. With this particular opinion, there are sort of two general issues that were identified. The first issue involved the evidence of a crime query that the court focused on, and there was an issue with respect to reporting that particular matter in a timely fashion. We had a situation where a national security analyst was conducting a query against 702 collection, and during the course of that query, identified potential evidence of a crime involving child abuse. And in following up, trying to determine if there was any other information with respect to that particular incident, conducted a second query, which could be considered a query searching for evidence of a crime. No additional information was found by that analyst, but ultimately that information was passed to the appropriate authorities to ensure that the victim child was protected in that particular case. There was an issue with reporting that particular matter in a timely fashion. So moving forward, we are going to ensure compliance with the policies already in place so that when we identify issues like this, or whether we identify issues involving how we store our raw FISA or how we disseminate our raw FISA, we will ensure our national security agents and our national security analysts are educated with respect to those pitfalls and educated with respect to the reporting requirements as well.
Senator Feinstein.
Thanks, Mr. Chairman. I wanted to talk to you about the about issue in intelligence, and I have my intelligence staff here today. We've been trying to look for an amendment. Let me see if I understand the issue correctly. Apparently, earlier this year, the NSA decided to end its practice in gathering abouts. It's part of upstream collection in 702. As I understand it, an example of an about is an email that includes the targeted email address in the body of the email, even though neither the sender nor receiver are themselves targeted. Is that correct?
Yes, Senator Feinstein, that's correct.
Thank you.
But can I just add, it's very important to remember that at least one of those senders or recipients is a non-U.S. person who's outside the United States.
Thank you. That's helpful. Thank you. Now, the NSA has noted that the intent is, and I quote, to retain the upstream collection that provides the greatest value to national security, while reducing the likelihood that NSA will acquire communications of U.S. persons or others who are not in direct contact with one of the agency's foreign intelligence targets. That's an NSA statement about upstream activities. Now, comment on that approach, and would the NSA work with us on trying to work something out that covers this issue properly? I don't know that we can do that legislatively, but I'd like your comments.
Yes, ma'am. You know, from NSA's perspective, we would be very, very nervous about a legislative prohibition on abouts collection for a couple of reasons. First off, the reason we terminated it was we do not have today a technical means to make us comfortable that that our analysts would be able to comply in all cases with the restriction on running U.S. person queries against upstream collection.
From that, what your statement, that NSA terminated it for that very reason, do you believe that the only way to handle it is terminate it overall?
No, ma'am, because
Okay.
The agency has a lot of smart engineers, and we think that given enough time, we might be able to come up with a technical solution that addresses the court's concern. And of course, the other thing we would have to weigh is operationally, what are we seeing in the operational environment? Because this is always a trade-off. What's the foreign intelligence loss? And there was definitely foreign intelligence loss when we made the decision. And so if we're able to recover or
is that notable, foreign intelligence loss?
It's hard to say what you're not getting, right?
Yeah.
So, I mean, but using the example you used at the outset, certainly from a counterterrorism standpoint, you'd be very, very interested to know that two people that we didn't know about already have the email address of a terrorist who practices really good communication security. That's an interesting fact to us that we would be interested in. So that's why we have hesitance about a statutory bar to resuming abouts.
And if I could add just one more thing, the other thing that I think is important to keep in mind, if NSA were to develop the technology or additional minimization procedures to address this issue, they would have, and we would have to go back to the FISA court and seek a approval. So there is a check to make sure that if this is turned back on at the appropriate time, it's done so in a lawful and appropriate way.
Time is going to expire. What do you suggest we do about abouts? Nothing? Try to work with NSA on an amendment? We'd rather get it right than wrong. If everybody could comment, because this is going to be a big issue.
I think our position is we should not do an amendment and reauthorize it as is, recognizing that Congress and the court will weigh in again if it's turned on.
And you're speaking for whom?
For the DNI.
Okay. Mr. Evans?
Senator, I would say from the Justice Department's perspective, the FISA court has on numerous occasions found the abouts collection to be lawful under the statute and under the Constitution. And so from our perspective, this isn't so much a legal issue as it is a technological issue, as Mr. Morris was indicating, of whether NSA can develop more robust technology and potentially more robust procedures.
That's the position of your agency?
I believe so, Senator.
Mr. Gaddis?
Senator, obviously, the more data we have that is at our disposal, the better we are and the more efficient we are at finding potential attackers here in the United States. So given the position of the FISA court with respect to abouts collection, if there's a technological way to resolve the issue, and if we would have a lawful manner with which to conduct our queries against that data set, that would be helpful for us.
Mr. Morris?
Yes, as I said, NSA opposes a statutory change at this point because that would box us in and possibly have unintended consequences.
Are you saying you would oppose a statutory?
Oppose, right. Yeah, we don't think it would be a good idea at this time.
Huh. Thank you. That answers my question.
Senator Grant.
Thank you. Mr. Morris, I've got numbers here. I want to make sure they come from the NSA. In 2016, there were 3,914 702 reports contained U.S. person identities. Would that number have come from your agency?
Senator, I believe that came from the DNI transparency report, but yeah, that number sounds like it was ours.
Okay.
Yeah.
It says that 1,934 of the U.S. persons identified were originally masked, but later unmasked in response to specific requests. Is it possible for this committee to find out who made those unmasking requests?
I believe we have a request like that pending. I'd have to take that back, but
if I'm talking to the Russian ambassador in the United States and he's been nominated as a target, would my conversations be incidentally collected?
On those facts, the Russian ambassador inside the United States could not be a target of Section 702 because he's inside the United States. So
would there be a warrant required?
Yeah, you would have to get a Title I order to target him in the
Well, apparently we're following the Russian ambassador, if you believe the newspapers. How did we follow him?
Well, Senator, from a legal perspective, and I can't talk about specific targets.
How do we follow the Russian ambassador?
Foreign officials located inside the United States, surveillance of them would have to be conducted pursuant to a traditional probable cause-based FISA order.
Okay.
Surveillance directed at foreigners
So let's
abroad
assume for a moment that the National Security Advisor in transition is talking to the Russian ambassador, and the Russian ambassador is outside the United States. Can you collect without a warrant?
Foreigners abroad who
Well, he'd be outside the United States. He's a foreigner. Could you collect without a warrant?
If the foreigner abroad was reasonably expected to communicate and possess
Nominated.
foreign intelligence information relevant to a certification, then yes.
Okay, so if he's in the United States, you can only collect if you have a traditional warrant, is that correct?
A FISA court order warrant, yes.
Okay. Is it possible to find out if I, Lindsey Graham, was instantly collected talking to a foreign leader abroad? Is that possible?
Senator, we would have to comply with the terms of our minimization procedures, which generally restrict us from deliberately.
Am I entitled to that information? Am I entitled as a United States Senator to know whether or not the intelligence community monitored a conversation I had with a foreign leader abroad?
The minimization procedures permit us.
Am I entitled as a United States Senator to know if my conversations with a foreign person overseas was collected and if somebody made a request to unmask me?
If, as a member of Congress, there's an intelligence report that reports on activities that include you and a foreign minister, by default, your identity is going to be masked. If there is a request to unmask a congressional identity, there is a process known as the Gates procedures that were established in the 1980s by former DCI Robert Gates that requires the agency to seek approval from the DNI before that unmasking.
Am I entitled to know if that happened to me?
When there is a Gates request, Congress is notified the leadership.
So if nobody's notified me, I assumed I wasn't collected upon.
Generally, those notifications are going to go to the leadership and to the leaders of the intelligence.
Well, I don't care. Well, I'm not asking about the leadership. I'm asking about me. I want to know if I'm overseas or if I'm talking to the Russian ambassador in the United States, apparently y'all are listening, if you believe the papers. I don't know how you're listening. I assume you got authority to listen. I don't really mind if you're listening. I do mind if somebody can take that conversation and use it against me politically. Is that possible under the current system?
So I completely agree that any political use of intelligence is wrong.
Would you agree with me that whoever leaked the conversation between Mr. Flynn and the Russian ambassador did a lot of damage to Mr. Flynn?
I think we would all agree at this table that any leak of classified information causes immense damage to national security.
So let's get back to 702. I'm overseas talking to a foreign leader, which I do a lot. If they're collecting on that foreign leader, I want to know, is it possible for somebody in the administration to get a hold of the conversation and unmask me? Is that possible?
Yes, I mean.
Is it possible for me to know if that happened?
Well, as Mr. Brooker explained, that the notification that happened.
I'm talking about to me. I don't.
Right.
Can I find that out? Yes or no? Do I have the legal right as a United States Senator to find out if my government is monitoring a conversation between me and a foreign leader? And if anybody had access to that conversation?
So we have worked with the chair and ranking member of the intelligence committees to support member requests for questions on Gates.
So
Absolutely,
is it legal or not for me to make that? I mean, does the law allow me to get that information?
It's my understanding, Senator, we have that request from you, and we are processing.
Yeah, it's like months ago. So, like, am I ever going to get it in my lifetime? And if you're not going to give it to me, tell me why.
I'm not stopping you. I just want to, I wish my colleagues would appreciate what he's trying to do here and give him a little extra time. So proceed.
So what's the deal?
In other words, I want you to proceed until
Thank
you
you.
get an answer.
Yes, sir.
I mean, if there's anything in this country people are entitled to, it's entitled to at least an answer to their question.
I'm violently agreeing with you. So if I were you, I'd answer my question because he's mad. So what's the answer here? Am I ever going to get to know the basic facts? Because if I'm going to be monitored overseas, maybe there's a good reason to monitor the person I'm talking to. I just want to know what consequence as a senator flows my way. If somebody in my own administration doesn't like me, the other administration outside of my party doesn't like me, should I be worried about that conversation falling in the hands of political people that may one day be used against me?
So as career intelligence professional, Senator, I don't think you should be concerned because
then answer my question then. Answer my question. I'm very concerned until I get an answer.
And we have your request. I know we're working on it. We have
What is
communicated with.
keeping you from answering that question?
So my understanding, Senator, is your requests any information about you, which we tried to narrow it with your staff. They said anything and everything, which would require every news clip, every
I don't
article.
want every news clip. I want to know conversations I may have had with foreign leaders that were monitored or foreign people that were monitored.
And so we specifically asked if working with your staff, if we can narrow it to Gates' requests where information about you was masked, and they said no. We are working with your staff to try to get you an answer as quickly as possible.
Is there a legal reason you can't answer that question?
Not a legal reason.
Okay, thanks.
Are you satisfied?
Not really, but we'll move on because other people have important questions too.
Senator, I think Senator Franken. Oh, I'm
Senator
sorry.
Klobuchar
Then
was
Senator
next.
Klobuchar, whatever Senator Feinstein
Here's,
says, go ahead.
Early bird.
Senator Klobuchar.
Thank you very much. Thank you to the panel, and this is along the lines of following up on what Senator Graham was talking about, and that is our oversight in a more general term. I know that Senator Coates testified before the Senate Intelligence Committee recently, and he said that Section 702 surveillance provides critical foreign intelligence that cannot practically be obtained throughout other methods. And I agree that that is true, and maybe I'll get to some examples from you about that. But as you can see from Senator Graham's questions, we still have a lot of reason to want to do oversight on the behalf of the public. And notably, your joint testimony urges Congress to reauthorize the FISA amendments without a sunset provision. As you know, this would effectively mean that Congress would not have to take up FISA reauthorizations in future years. We would actually have we could have hearings, I guess, but we would have no leverage to get changes or to work on things. We wouldn't have the opportunity to discuss what is working and what is not working as we did today. So can you provide more context as to why the administration is requesting that Congress reauthorize these FISA authorities without a sunset provision? And is that set in stone? I guess we'll go through the, Mr. Brooker.
So I'll start. I think we have nearly a decade of FISA 702 experience under our belt now. I think review after review have shown that there have been mistakes, but nothing intentional. I think the statute is built with a significant amount of both congressional and public transparency built into it, that whether or not there is a sunset, this body, through sort of public oversight and classified oversight, has the ability to do the exact oversight you're talking about. We're required under law to produce significant FISA court opinions to this body, to report compliance incidents, to come at request. So I do think there are mechanisms built into the law to allow Congress to do the exact oversight, whether there's a sunset or not.
But as Mr. Graham has pointed out here, we're dealing with important privacy issues and that balance between security and privacy. And I think what we have decided over the years with bipartisan support is that we want to be able to have that leverage to be able to make changes. And it's much harder when a law is just in permanently. And in fact, a lot of our laws have sunset provisions. So I guess I still go back to, is this set in stone that the administration doesn't want to have a sunset provision in here?
I think if you were to ask me the question, would you like a sunset or no bill at all, I would say we would like a sunset.
I understand. Okay, that is a very good answer. Mr. Evans, do you want to add anything?
Senator, I would just reinforce one of the points that Mr. Brooker made about the continual oversight of Congress between the sunset periods. We produce, as Mr. Brooker indicated, not just significant FISA court opinions, but detailed reports at least twice a year on every compliance incident under the Section 702 program. Those are then subject to briefings with the judiciary and intelligence community staff and/or members as appropriate. And so from our perspective, it's a continual oversight process that Congress is engaged in. And should there be something troubling or alarming that Congress becomes aware of during any of those briefings or reports, it's always Congress's prerogative to act during that period, with or without a sunset.
Exactly, but you did hear Senator Feinstein's remarks that she would not support this without a sunset. Okay, very good, which many of us join in on. Mr. Gaddis.
Senator, I think we all agree that there needs to be a balance to strike between protecting the civil liberties of Americans and protecting the American public from attacks as well. We have all stated very emphatically the value of this section in terms of helping us protect the American public from attacks, counterterrorism, cyber attacks, and so forth. It is an absolutely critical tool for us. At the same time, we respect the privacy issues that this committee has raised. And just to echo what my colleagues have said, in addition to the congressional oversight, the oversight from DOJ, we all have our internal minimization procedures that we comply with every day. We have our monthly audits that are conducted. We have the training sessions that are conducted. So there are a variety of compliance and oversight measures that are currently in place. The lack of a sunset provision will not do away with those layers of oversight, nor will it do away with the authority of this committee or any of the intelligence committees.
Mr. Morris?
Yeah, so one of the reasons that we're seeking a permanent reauthorization instead of having a sunset provision is a sunset provision leaves the status of the law somewhat unsettled, and so you don't know whether you're a provider that is served with the 702 directive. Is this something that I'm going to have to worry about the next year or the next year after that, or after the next sunset provision? So we want some sense of continuity because it's not just the government that's implementing this, right? So the providers have requirements that they have to consider. It's also important for the intelligence professionals who do the work every day. A permanent reauthorization certainly is a vote of confidence that they are doing the right thing and doing the work well, and that the tool that they use to produce valuable foreign intelligence is still going to be there come January. So that's another reason we support permanent reauthorization.
Well, I think it's pretty clear. Senator Feinstein is the former chair of the Intelligence Committee, and as someone from law enforcement, I have utmost respect for the people doing this work, and I've tended to be someone that has sided more on the security side in terms of the necessity for the reauthorization and support for the work. But I do think when we have these unsettled issues still, I don't think everything is settled, as you could see from the exchange with Senator Graham, which is why many of us do favor the sunset provision staying in place. But I appreciate your good work. Thank you.
Thank you, Mr. Chairman, and thanks to all of you for being here and for your testimony today. I want to be clear at the outset. There are good reasons for us to have concerns about the application of this law. The American people have long understood that the power of government can easily be abused. A special committee of the United States Senate concluded a few years ago, about 40 years ago, that in every presidential administration from FDR all the way through Nixon, the administration immediately preceding the work of that special committee, the intelligence gathering agencies of the federal government had been used to engage in political espionage. This is, of course, very significant. It's of obvious concern to anyone who works in this city or in government in any way. In addition to that, there is a reason why we have the Fourth Amendment. There are all kinds of implications that extend far beyond the political realm, where the rights of the accused need to be protected. And notwithstanding the fact that we want government to be able to do its job to protect us from those outside our country who would harm us, we also want to make sure that those same authorities can't be used to harm individuals. The Fourth Amendment, in fact, makes government less efficient. It, in fact, makes it more difficult to be the government. But it's also very, very necessary. In any administration, regardless of which political party is at the head of it, it's important that we not lose touch with the Fourth Amendment, either the letter or spirit thereof. Section 702 of the Foreign Intelligence Surveillance Act amendments authorizes the surveillance of certain foreign intelligence activities. That definition includes information that is directly related to things like national security and national defense, things that are directly related, for example, to a potential terrorist attack. But it also includes information that, quote, is relevant to the foreign affairs of the United States, close quote. This latter category is broad, is much broader, and it is broad enough, I think, to be used to target just about anyone abroad, including a political activist, a human rights volunteer, business people, students, journalists, doctors, just about anyone traveling abroad. At a hearing before this committee earlier this year, the FBI director testified that it would not be problematic for the FBI to limit collection of foreign intelligence information to information that is itself limited much more to the national security universe. So let me start by asking Mr. Evans and Mr. Brooker, would this be problematic? Is there any reason why we couldn't and shouldn't limit the use of Section 702 to something that's related to a national security threat?
Thank you, Senator. I am familiar with the exchange you had with then Director Comey during that prior hearing, and while I certainly can't speak for what he was thinking with his answer, as I understood his answer, I think he was referring to the FBI's use of Section 702, which, as Mr. Gaddis described, the FBI can only receive Section 702 information when it's part of an authorized investigation that they're conducting, which typically relate to the types of threats that Director Comey described. As to talking about potentially changing the definition of foreign intelligence information more broadly, I think that's something that would be difficult to do in an open session here without having the ability in a classified session, which we could certainly get into tomorrow, to describe for you the specific types of collection that are ongoing now and how any potential changes to the definition of foreign intelligence might affect that.
Well, is Section 702 currently used abroad to target people who are themselves not related to national security threats?
Section 702, and I'll just walk through the statute here briefly. Section 702 can be used, as you noted, to collect on foreign intelligence information as that's defined by statute. Now, within that definition, there are certifications executed by the Attorney General and the Director of National Intelligence that describe the specific types of foreign intelligence information appropriate for collection. Those specific categories in those certifications are classified, so I can't get into them here. But importantly, though, as to your point about targeting any innocent foreigner overseas, as Mr. Morris indicated, I think in his opening remark, a foreigner overseas can only be targeted under Section 702 if there's a reasonable belief that that person is likely to communicate or possess foreign intelligence information as it relates to one of the specific certifications. That justification, laying out why that person is reasonably likely to communicate or possess that information, has to be documented by the analyst and then is subject to back-end auditing by the Department of Justice and Director of National Intelligence to ensure that it's appropriate and related to the actual topic of the certification.
Okay. My time's expired. Mr. Brooker didn't have a chance to answer that. I don't know if Mr. Chairman, is it okay if he...
Thank you. Like Mr. Evans, I think this is best a discussion for tomorrow where we can really go into detail about the type of targets we are after under 702.
Thank you, Mr. Chairman. And before I begin, I'd like to thank you and the ranking member for holding today's hearing. The subject of today's hearing strikes at the very heart of the debate about how to safeguard national security without trampling on Americans' fundamental right to privacy. As I've said before, but I think it bears repeating, when the American people understand the scope and scale of our surveillance programs, they're better able to judge for themselves whether the government is appropriately balancing privacy and public safety. That's why I've focused on the issue of transparency, most recently back in 2015 when Congress debated and passed the USA Freedom Act. USA Freedom was a bipartisan bill to reform our surveillance programs, and I was proud to join my friend Senator Dean Heller in writing the bill's transparencies provisions. When the public lacks even a rough sense of the scope of surveillance, they have no way of knowing if the government is striking the right balance. So we wrote the provisions that now require the government to issue detailed annual reports about the information collected under our surveillance authorities. For certain surveillance programs, the government must also say how many times it sifts through that information to search for Americans' communications, and that is important stuff. As the former general counsel for the Office of the Director of National Intelligence said, quote, "With secrecy inevitably come both suspicion and the possibility for abuse. So in my view, transparency is critical to gaining the public's trust and guarding against misuse. Transparency was critical with respect to the reporting required by USA Freedom, and it is critical with respect to the number of Americans inadvertently swept up in 702 collections. So I remain disappointed that despite bipartisan demand for this information, we still do not have even an estimate of how many Americans have had their phone calls or emails collected under Section 702. Members of the Senate Intelligence Committee have asked for an estimate. Civil society groups have asked for an estimate. Representatives Sensenbrenner and Conyers have asked for an estimate, but no one has received a satisfying answer. Mr. Brooker, do you agree with former ODNI General Counsel Bob Litt that, quote, there would have been less public outcry from the Snowden leaks if the government had been more transparent about its activities beforehand? Do you agree that without some form of transparency, we risk suspicion and also the possibility for abuse?
I think we all agree that transparency is important. I think you can see in our transparency report that we released largely with your leadership, we actually went beyond what the law requires for the amount of information and numbers we reported, and that transparency has continued in this administration with the release for the first time of the targeting procedures that are used under these procedures. I want to sort of stress our inability to release a number on the number of incidental USPs that have been collected is not for want of trying, and we can discuss this in more detail tomorrow, and NSA can walk through sort of the Herculean efforts they've taken really over the last 18 months to try to find a way to do it that's responsive, coming to the conclusion that there's not a way to produce a transparent number that's meaningful to the debate, that's not something that's wrong, that's accurate, is sort of critical, and we're happy to get into that tomorrow in more detail.
Well, you know, for example, Director Coates said it'd be infeasible to come up with a way to count the number of Americans whose communications are collected under 702. But help me understand this. Is your contention that our intelligence agencies, while they're capable of collecting vast quantities of information, phone calls, text messages, emails, and sifting through all that data for specific information like a name or a phone number, but the agencies are somehow not capable of counting how many Americans are swept up in that surveillance?
That's right, Senator. I think at bottom, if you look at an email, we know who our targets are, and our target's going to be an email. We don't know necessarily who our targets are talking to, and you can't tell whether, you know, bad guy at hotmail.com is a U.S. person or not based simply on his email address. We know our targets are foreigners overseas, but we can't identify without significant additional research more.
Well, I'm out of time, but I would just ask if it's possible to come up with an estimate and not specific numbers, and it seems to me that we are really already capable of coming up with that estimate. A 2011 opinion by the FISA court revealed that the NSA previously reviewed a random sample of, quote, internet transactions to determine how many of those communications were wholly domestic. And I think we can come up with an estimate. Thank you, Mr. Chairman, for your indulgence.
Senator Cornyn.
Thank you, Mr. Chairman, and thanks to the witnesses for being here today to talk about the crown jewels of the intelligence community when it comes to keeping America safe. I can't help but just offer a thought, Mr. Brooker, on the questions my friend Senator Franken asked about wanting to identify the number of Americans incidentally collected against. As I understand from the Director of National Intelligence, Coates, basically the reason why the intelligence community cannot produce that is because by structure, design, by law, by regulation, the intelligence community is prohibited from gathering intelligence against domestic targets like American citizens without a court order and a showing of probable cause that some crime has been committed. And so it strikes me as not intentionally unfair, but unfair in the sense of the design and structure of the intelligence oversight and regulatory framework to then ask you to produce the names of Americans incidentally collected against when the whole law is designed to limit, if not to prohibit, that collection absent a court order. So I know that on the Intelligence Committee, which I have the privilege of sitting on with Senator Feinstein, I know Senator Wyden has been an ardent advocate of producing a number, but I think it would create, if it was possible, which I agree that under the circumstances is not possible to come up with a reliable number, and for the reasons I mentioned, but I think it would also add fuel to the flame of some of the conspiracy theorists who seem to think that our intelligence community is doing things which it is legally prohibited from doing, and thank goodness for that. And that would be targeting American citizens without observing the formalities of constitutional rights under the Fourth Amendment. So I think under the circumstances, the political environment we find ourselves in is how do we preserve the crown jewels of the intelligence community under 702 and reauthorize this important tool used by the FBI and by our intelligence community, and also reassure the public that the oversight that takes place, whether it's internal at the NSA or whether it's congressional oversight at hearings here and in the Intelligence Committee, or the judicial oversight that takes place before the Foreign Intelligence Surveillance Court, how do we reassure the American people that those oversight mechanisms, those checks and balances are working the way they should in order to protect the civil liberties of American citizens while still empowering the intelligence community to do what you need to do and what we need to do in order to keep our country safe. And so the kinds of questions that Senator Graham was asking, I think, are, if in fact warranted, if the answer is not what I would hope it would be, that there are either inadvertent or intentional violations of the law and the regulations, that would certainly help to undermine confidence and make it much harder for Congress to do what I believe we have to do, which is to reauthorize this very important statute. That would include any unauthorized unmasking of names under the previous Obama administration. We need to find out what the facts are there, and we need to, if in fact it's not warranted by an investigation, what the facts are, we need to make that clear, because that's the kind of thing that I think does undermine public confidence and indeed undermines congressional confidence, which makes it much harder for us to do what we need to do when it comes to reauthorizing this legislation. Finally, just let me say, I know it's hard to debate these topics in public because so much of what you do is classified, and necessarily so, and based on a need to know. But I would just ask Mr. Gaddis and Mr. Morris, would you add a little more color and context to some of the success stories, if you can, of how this tool has been so useful in protecting the country?
Yes, sir. I'd be happy to. I spoke about an example in my opening statement regarding an individual overseas who was part of an ISIL facilitation network. I can also walk the committee through and the American public through another example which occurred overseas and that also impacted Americans overseas. This occurred on December 31st of last year in Istanbul, Turkey. There was a particular individual who was targeting a nightclub there in Turkey and was going to conduct a terrorist attack at that particular nightclub. He did, in fact, conduct that attack, as I'm sure you know by now, and was responsible for the deaths or injuries of 38 people from 14 different countries. One of those individuals was an American who was shot in the hip. In working together with our foreign service partners in Turkey, we were able to identify the individual who conducted that attack. And we were able to go up on Section 702 collection on that particular individual. Based on that collection, we were able to identify where that individual was located and pass that information to the appropriate Turkish authorities, who then apprehended him, took him into custody. So it was instrumental in helping us find an individual who had perpetrated an attack in another country. It helped us find an individual who had shot an American citizen, and it helped us prevent that individual from acting anymore based on his own planning or ideology.
Thank you, Mr. Gaddis. My time is up, so Mr. Morris will save that for another time. But I would just encourage you all, and I know that's something that the... Go ahead, Mr. Morris.
Thank you. Whenever we declassify one of these operational examples, we literally sweat every word to make sure that we're not going to reveal something to our targets that will allow them to evade detection. But I'll use another example. It's a bit dated now, but I think it's very, very illustrative of the importance of the program. In 2009, during the summer, we NSA we had 702 coverage of a terrorist in Pakistan. We noticed that the terrorist received an email message from somebody indicating that it looked like they were involved in imminent attack planning here in the United States. We tipped that information to the FBI. The FBI subsequently determined that the individual was a gentleman by the name of Najibullah Zazi, and he and his Confederates were planning to do a bombing of the New York City subway. That tip from 702 allowed us to avert a very credible and real threat against the New York City subway. Part of the reason, it's a dated example is because we feel now that, we're not going to reveal sources and methods that would help the adversary. But again, it's a difficult process, but we certainly appreciate the need for examples like this so the American people understand how we're actually using the authority.
Senator Durbin.
Thank you, Mr. Chairman. First question, why are we here? And I think we need to reflect a little bit on history. After the 9/11 terrorist attack, the Bush administration secretly began spying on American citizens in the United States without judicial approval required by the Constitution and without the authorization from Congress. Years later, this committee heard dramatic testimony from former Deputy Attorney General Jim Comey about the efforts of White House Chief of Staff Andrew Card and White House counsel Alberto Gonzales to pressure Attorney General John Ashcroft into reauthorizing this surveillance while he was hospitalized. After the New York Times revealed the existence of warrantless surveillance programs, the Bush administration demanded that Congress pass legislation authorizing the program. This led to the FISA Amendments Act in 2008. I opposed it, as well as its reauthorization in 2012. I still have serious concerns that it doesn't include adequate checks and balances to protect the constitutional rights of innocent Americans. Now, we all support giving the intelligence community the tools they need to keep America safe, but we also live in a democracy. All of us have sworn to uphold and defend the Constitution, which limits the power of government, as Senator Lee has said. So, Mr. Morris said, in defining 702, in the simplest terms, it is only used to target foreign persons living outside the United States. If that were all, we wouldn't be talking about it. I think most of us would agree. Keep America safe. If someone outside the United States plans to do us harm, we want to know about it and stop them, period. And then we want to stop them further, perhaps by arrest or even more. But we also know that caught up in the information collected of those so-called foreign sources is information about Americans. Did you hear the exchange with Senator Lindsey Graham? Did you note the emotion in his voice as he thought about the possibility that his privacy was being invaded by his government, that someone might use that information through 702 against him as a United States Senator? You just witnessed something which is rare in the United States Senate. This chairman rightly said, let's extend the time of the senator to keep asking, because we're all concerned about that, because it's our privacy that Senator Graham has raised. But what about the privacy of the Americans who are not in this room? Well, now we run into another problem. Senator Franken asked you the most basic information. How many Americans have been swept up into this 702? You can't tell us. How are we supposed to believe that transparency is really the guiding principle and that we have such great data collection if you can't even identify for us how many Americans have been innocently swept up into this effort and can't answer Senator Graham's most basic question. So, Mr. Brooker, how are we supposed to have confidence that you're being careful not to involve more people than necessary to keep America safe, not to avoid the constitutional requirement of a warrant if you want to know something about Durbin or Graham or Franken or someone else?
It's a hard question, Senator. I think, like you, everyone at this table is concerned about our privacy and the privacy of our families, my folks in Arizona, my in-laws in Alabama, something we think about day in and day out and take very seriously. I think that's why the oversight of this committee, the oversight done by the FISA court and the Department of Justice is so critical to this process. You know, I think while we are unable to provide an absolute metrics on the number of U.S. persons incidentally acquired, we report a lot of information to this committee in classified form and a lot of information publicly relating to the number of U.S. persons unmasked.
Senator Graham couldn't get the basic information about it himself. I've been with him on trips overseas, and all of us, you know, we're in conversation with foreign leaders on a regular basis. The notion that our government has captured that conversation is something we ought to know about. If you tried to do it in the United States, you'd need a warrant. If you did it when we were overseas, apparently not. And he's asked a basic question which for months has gone unanswered in this process. So I guess it comes down to the very basics here. We have seen over time, since the creation of these FISA Act amendments, a broadening of the power of the United States, the lifting of the requirement for warrants from the FISA courts. We've given you more and more and more authority. All we're asking is, how carefully are you using it? How closely are you following the Constitution as you use it? What efforts are you making to protect the innocent Americans who've done nothing wrong and just happen to be caught up in a communication, or whose name is mentioned in a communication, and you tell us, hard question, we'll get back to you later? It is a hard question, but it's really fundamental. And I think it really raises questions about what we need to do if we truly want to uphold and defend this Constitution and still keep us safe. Thank you, Mr. Chairman.
Thank you, Chairman, and thank you all for being here. To follow up on the point that Senator Durbin was making, each one of your agencies has internal administrative procedures that allow the agency to police the use and misuse of 702 information. We on the Judiciary Committee do not have a comprehensive or consolidated statement of what your own internal protections and safeguards are. I would ask you as a question for the record to get your heads together and create a document that explains for us all the different ways in which you, through privacy councils, inspectors general, procedures, police the use and abuse of 702 information. I think part of what we're seeing here in terms of the frustration is that we don't have a clear exposition of that. And you ought to be able to give it to us. That ought to be pretty straightforward stuff. So with the chairman's permission, I'm going to ask that as a question for the record. Second, there are concerns about the unmasking of individuals who turn up as, I'm a former prosecutor, so let me say, unindicted co-conspirator, not a real name, just subject A or whatever, in the intelligence. There's a specific allegation that has been floating around that the conversations between Michael Flynn and Ambassador Kislyak came into the White House with Flynn masked, and that a decision was made in the Obama White House to unmask him, which then led to leaks to the newspapers and so forth. I think we can all agree that an unmasking request for a political motive that leads to a leak is not a good thing. But it's important to us to get the facts of that right. So tomorrow, when we're in classified setting, I want to give you a preview of coming attractions. I would like you to be able to answer the question of whether or not that state of facts actually transpired. What happened? Did the name come in masked or unmasked? Was it masked or unmasked as the result of a request out of the White House? And do you have any information about the leak? Okay? You don't need to answer that now. And at some point, I'm going to want to go back at you because a lot of stuff you tell us isn't really classified, but we hear it in a classified setting, so we can't talk about it. So we're going to have to sort out what's really classified and what isn't, but at least be prepared to answer that. And the last thing I wanted to mention is with respect to this question of how big does the 702 reach penetrate into ordinary Americans' lives. And a lot of this, I think, boils down to a definition of what we mean when we say, to use again Senator Durbin's phrase, swept up. Who's swept up in this? As I understand the process, and correct me if I'm wrong here, you have identified overseas targets who you are allowed to collect on under 702, correct? Yeah,
Correct.
okay. And you don't know who they are in touch with until you query that selector in your database, correct?
There's a number of different ways, Senator, that we can review collections. So, for example, there may be a target where our analysts are going to review every communication.
But it takes an act of selection to pull up that review, right?
Yes, correct.
Okay. And then once you've got your target, you've got the query that's been asked, however it's asked, that calls up everybody who they've been in touch with, and then once you've called that screen in, you still don't know the nationality or the location of an individual because all you have is electronic metadata, and it takes individualized research to figure out the location and the identity of those people. Is that also correct?
That is often correct, yes.
Okay. So in order to figure out who is swept up, so-called swept up in all of this, what you would need to do is to look at your roster of legitimate 702 targets, query every single one of them for everybody that they've been in touch with, which would presumably be a fairly massive undertaking, and then do the address by address individual identification to figure out which ones were Americans or on American soil at the time. Is that the problem with trying to get to this?
I think that's right. And oftentimes there's not that electronic information to understand for the other communicants, our non-targets, who they are or where they are.
And in terms of the privacy interest of individuals, the fact that their email information is sitting in a data place somewhere that no human being has ever looked at, if suddenly we went out and started pulling up that stuff to do this count, that is actually looking into their privacy in a different way. There's actually now human eyeballs on that, whereas before they were just in an electronic database that may have never turned up to any human eyeball.
Correct, and we would likely, and I would defer to Mr. Morris, have to do additional research outside of what NSA would normally do to try to figure that out.
Understood. Okay. See you tomorrow.
Thank you, Mr. Chairman. On these questions, fascinating. Senator Whitehouse's and that's what Senator Durbin was asking, but everybody's asked. You can see the kind of concern in this panel. Earlier this year, the NSA terminated their bout collection. There have been a number of compliance incidences relating to that. They discovered these compliance issues. They did a broad overview of the 702 program, and they decided the bout collection was too great in privacy. Mr. Goddard says, when was the last time the FBI undertook a comprehensive review about how to obtain searches and uses 702 data?
Sir, we have measures in place through which first of all, we train our national security agents and analysts.
When was the last time you did it, like the NSA did, when was the last time you did a comprehensive search about how to use it?
We have regular audits that we conduct internally, and we are also overseen by DOJ, who conducts periodic audits as well.
When was the last one?
I believe the audits in one of those instances is monthly.
And was that a complete audit of the whole program?
It was not. It was an audit of a segment of the program.
When was the last time there's been an audit of the whole program?
I'd have to get back to you with that answer, Senator.
Can you get back to me today?
We can try to do that, sir.
Please. It'd be helpful before the meeting tomorrow. And I'd ask Mr. Brooker and Mr. Morris, we've heard that the intelligence community opposes the statutory restrictions about collections. They say it's a technical issue, not a fundamental privacy issue. So I ask you both, is the NSA currently working to fix this technical issue, or does Congress give it indefinite license to engage in this type of collection in the future?
You want to start?
Yeah. Senator, we're always looking at ways to improve the technical controls that we have in place. We do not have at present a plan to try to reinstitute abouts, but the problem is we tried to explain a bit earlier, is that if the operational environment changes, our targets start acting differently, we may determine that we need to come back up on abouts, and having a statutory restriction would make that very difficult to do, whereas if we were able to come up with a technical fix that is satisfactory to the court, then being able to come back up would just be a matter of making sure that we get court permission.
When do you think you'd have a technical fix?
I can't hazard a guess. I'd have to get back to you, sir.
Thank you. Did you want to add anything to that, Mr. Brooker? Okay. Let me ask a question, Mr. Evans. Director Coates, when he testified, he said that compliance incidents, like those that result in the termination of the about collection, are always reported, and they're always corrected. Well, not everybody feels that way. The FISA court recently said otherwise. In April, the FISA court chastised the government for failing to fulfill disclosed compliance incidents, and for and this is their words, an institutional lack of candor on a, quote, very serious Fourth Amendment issue. Mr. Evans, that's kind of tough language from the FISA court. What reforms has the Justice Department undertaken to make sure there's full and immediate disclosure of the government's surveillance activities to the FISA?
Thank you, Senator. As to reforms and additional measures, I think Mr. Morris may want to comment on that, because I know the NSA takes very seriously its obligations to comply with the law and its relationship with the court. And I believe that the director of the NSA at that hearing you referenced also made some comments as to additional measures that he was putting in place. I can say from a Justice Department perspective, as you noted and as we noted in our remarks, compliance incidents do happen. We've never found an intentional one. They've been inadvertent. And candidly, they're frustrating for us when they happen. They're frustrating for the NSA when they happen. And clearly, in this instance, they were frustrating for the judge. But I think the 2 points that I would also take away from that, as the judge clearly indicated in her opinion, are that this incident was actually self-identified and self-reported by the government to the court, much to our detriment.
Is it routine to, if you find one like that, to immediately report it to the court?
It is routine to do so. Candidly, Senator, some of the issues on timing with these are complex matters technologically, legally, and sometimes it takes the agencies a little bit of time to wrap their hands around, is there a problem, what is the problem, and how to describe that to the court. We and the agencies look to do all of that as fast as possible, but we also want to get it right and be accurate about how we do it.
And if I may, Senator, if I may just expand on Mr. Evans' answer slightly. In the particular query incident issue that led to the court's comment about an institutional lack of candor, the timing was exactly, as Stu described, is exactly correct. That was the primary issue for us. We had initially reported the problem, I believe it was in 2015, and a report was filed with the court. The problem was we continued to do additional investigatory work. So our Inspector General's office was conducting studies to determine what is the scope of the problem. And the full scope and scale of the query problem didn't become evident until about 2.5 weeks after the court had held a hearing in October about the renewal of the certification. So when we went back to the court to say, oh, our IG just finished its study, it's actually a bigger problem, the court naturally was unhappy because this was new information that was being presented with just before it had to rule on the certifications. And I certainly appreciate why the court was upset.
The language of the court, they did not disguise their unhappiness.
Agreed.
Okay. I have one, if I may, Mr. Chairman, one more.
Then I'll call on Senator Feinstein.
Okay, thank you. Unlike the NSA and the CIA, the FBI can search for U.S. person communications obtained from Section 702 for evidence of conventional crimes, totally unrelated to foreign intelligence or national security. They can do that without a warrant. This raises some questions here. I mean, can you use that to go after things like drug offenses or tax fraud or anything of that nature?
Senator, if I could address that from a legal perspective first, and then Mr. Gaddis might have comments from an operational policy perspective. Just to the point you're raising and why that's permissible in the first instance from a legal perspective, although the collection we're doing is directed against foreigners abroad and must be for a foreign intelligence purpose, Congress recognized with Section 702, just as with traditional FISA, candidly, that it's possible that that national security surveillance might reveal evidence of a domestic criminal offense. And that's why the FISA statute itself, both for traditional FISA as well as for Section 702, requires that there be minimization procedures that provide for the retention and dissemination of evidence of a crime for law enforcement purposes when we happen to come across it. And as Judge Hogan concluded in a now declassified FISC opinion, because the statute requires us to retain and disseminate evidence of a crime, it would be perverse if we weren't allowed to similarly do the queries and look through the information we have to see if we have evidence of a crime. So that's with respect to the doing of the queries themselves. With respect to the use of that information, if we are going to be using any information obtained or derived from either Section 702 or traditional FISA in a criminal case against a communicant on that the communication, what the statute terms an aggrieved person, that person would be entitled to notice in the criminal case. However, as a policy matter, we've also put in place a department policy that was put in place, I believe, back in 2015 that says we will not, as a matter of policy, use communications to, from, or about an American as evidence in a criminal proceeding unrelated to either national security or a significant list of enumerated crimes. So a routine minor offense, we've committed that we will not use that in a criminal case.
Thank you, Mr. Chairman. I may have a further question when we go into the classified on this, but I appreciate that. Thank you.
One question, and then we'll call the second panel.
This question is for Mr. Gaddis. Mr. Gaddis, and your answer can be brief. Former FBI Director James Comey testified before the Senate Intelligence Committee on June 8th about one-on-one conversations he had with President Trump. Two of these discussions took place in person, one during a private dinner at the White House on January 27th, and the following a briefing in the Oval Office on February 14th. The president also called him on the phone, including calls on March 30 and April 11. Director Comey said that he discussed some of these conversations with his FBI leadership team. Without getting into what was said, were you involved in any discussions about President Trump's interactions with Director Comey? A yes or no would be sufficient.
Yes, Senator.
I don't want to get into detail now, but the committee may want to talk more with you about this. Will you commit to getting us the information that we need?
We'll work with the committee, Senator.
Thank you very much, Mr. Gaddis. Thank you, Mr. Chairman.
Thanks to all of you. We'll probably be using you for resources in the months ahead as we... Second panel, please come. Oh, did I cut somebody off? Okay, second panel then. And
Oh, thank you.
And,
I'm fine. Thank you. Very good.
Matthew Olson, first of all, welcome to all of you, all four of you. Matthew Olson is co-founder of IronNet Cybersecurity, previously serving as the director of National Counterterrorism Center, where he briefed the National Security Council and reported to President Obama on counterterrorism activities. Mr. Olson also previously served General Counsel NSA, focusing on surveillance law and cybersecurity. Under the Bush administration, Mr. Olson served as acting Assistant Attorney General, National Security Division, DOJ. Mr. Olson also served as Executive Director of Guantanamo Task Force, Special Counsel Director of the FBI, and served as federal prosecutor for more than a decade. He's a graduate of the University of Virginia and Harvard Law School. Adam Klein is Robert M. Gates Senior Fellow, Center for New American Security, widely published in areas of national security, surveillance, counterterrorism law, and policy. He was previously an attorney at international law firm. He has also worked on national security policy at RAND Corporation and the 9/11 Public Discourse Project, the nonprofit successor to the 9/11 Commission. Mr. Klein served as the law clerk for Justice Scalia and is a graduate of Northwestern University and Columbia Law School. Elizabeth Goteen co-directs the Brennan Center for Justice, Liberty, and National Security Program, New York University School of Law. Previously, Ms. Goteen served as counsel to the U.S. Senator Russell Feingold, chairman of the Constitution Subcommittee on Senate Judiciary Committee. Ms. Goteen also served as a trial attorney in the Federal Programs Branch of the Civil Division of the Department of Justice, and she graduated from Yale Law School. Elizabeth Collins is serving her second term as board member of the Privacy and Civil Liberties Oversight Board. Previously, she was an attorney in private sector at 2 international law firms and served as the Republican chief counsel for Supreme Court nominations for Senate Judiciary Committee. Ms. Collins was also an assistant attorney general, legal policy, DOJ, where she provided advice and counsel relating to national security and other issues. Ms. Collins is a graduate of the University of Chicago and Harvard Law School. We'll proceed my left to my right, so Mr. Olson, proceed, please.
Thank you very much, Chairman Grassley. It's an honor to be here this morning. Let me put the bottom line up front. As the former director of the National Counterterrorism Center, I can attest to the fact that Section 702 has significantly contributed to our ability to prevent terrorist attacks in the United States and around the world. This is consistent with the testimony that you heard from the panelists, the witnesses at the earlier panel. Similarly, as the former general counsel at NSA and as a former Justice Department official, I worked to ensure that we implemented Section 702 in a manner that protected the privacy and civil liberties of Americans. I will make a few brief remarks, and I will focus those remarks on 3 points, all addressing how Section 702 has worked in practice. First, the operational value of 702. As this committee is well aware, we face a persistent and adaptive threat from al-Qaeda and ISIS and other groups. Just since September 2014, ISIS has claimed credit for 40 terrorist attacks outside of its caliphate in Syria and Iraq. The online environment where potential extremists communicate with ISIS handlers and with recruiters plays a critical role in providing the direction to these individuals and mobilizing extremists toward violence. So to combat this dynamic threat, our ability to conduct surveillance under 702 has proven vital. The key point is this: our best opportunity to identify and stop these attacks before they occur is through good intelligence, and that's often derived from our surveillance authorities, such as 702. As the director of NCTC, I relied on a daily basis on intelligence collected under 702. In our morning briefings, the analysts often reported that a critical piece of information came from Section 702. In its landmark report, the Privacy and Civil Liberties and Oversight Board identified approximately 30 specific cases where Section 702 was the initial catalyst that uncovered previously unknown terrorist operatives and plots, and more than 100 cases where 702 helped to lead to the arrest of individuals on terrorism-related charges. This is a truly extraordinary record in just the past few years. My second point is oversight. When Congress amended FISA in 2008, I was at the Department of Justice. Congress established an unprecedented and comprehensive compliance and oversight regime for 702. Under this regime, as you've heard now, all three branches of government exercise authority to ensure that the government is properly using this authority. This oversight has been strengthened over the past several years through both congressional and executive branch action. This rigorous oversight regime reflects the careful balance that Congress struck in 2008 to ensure that both the effectiveness of this authority and the protection of privacy and civil liberties. In my experience, the statute has been effective in doing both. The third point I would like to make is to suggest that calls for major reforms are not warranted. One issue that the committee has heard about this morning is the so-called incidental collection issue. So a person targeted for surveillance under 702 who speaks on the phone or sends an email may often be communicating with somebody in the United States. This is what's been referred to as incidental collection. While some have raised concerns about such collection, I can tell you from my experience that the ability to obtain and use these communications has proven absolutely vital to the disruption of plots, to the arrest of al-Qaeda operatives here in the United States. The Zazi case that the committee is aware of and other specific cases are examples of this. I believe that Congress should resist calls to restrict the government's ability to acquire and use such information concerning U.S. persons. A second issue involves the ability to search 702 information with U.S. person identifiers, such as names and email addresses. I believe that these queries are essential means for analysts to identify critical intelligence that would otherwise be inaccessible. From an operational perspective, when intelligence analysts seek to identify terrorist operatives and uncover plots, one of their very first steps is to check existing databases for potential connections to suspected terrorists. So if the FBI suspects that a person here is moving toward violence, the ability to query 702 information enables the FBI to move quickly to identify communications that the government has already lawfully collected to find vital clues. I believe this approach reflects an enduring lesson from the 9/11 attacks. That is the imperative for the government to effectively integrate and use the relevant information it holds in its databases in order to connect the dots. Some are now urging Congress to impose probable cause requirements on intelligence agencies before they can even search Section 702 data with U.S. person identifiers. In my view, this would undermine the ability of intelligence analysts and agents to move quickly to identify terrorist information. At the early stage of an investigation, it may be impossible to establish probable cause, and therefore such data would be beyond their reach. In sum, Mr. Chairman, the authority of Congress established under Section 702 has played an indispensable role, in my view, in protecting the nation. And in operating this program under a strict oversight regime, the government has demonstrated it can collect vital intelligence in a manner that protects privacy and civil liberties of Americans. Thank you.
Thank you. Mr. Klein.
Chairman Grassley, Ranking Member Feinstein, and members of the committee, thank you for inviting me to testify today. In a recent report, two co-authors and I offered more than 60 recommendations for future surveillance policy, including Section 702. We concluded that Section 702 is a valuable intelligence tool that should be reauthorized with existing statutory authorities intact. But we also proposed enhancements to oversight, transparency, and privacy. The public should know that Section 702 is already subject to rigorous multi-layered oversight from all three branches of government. Few government programs receive such close scrutiny. That said, it is always worth considering what more we can do to protect privacy and strengthen public trust in intelligence programs. This isn't just a privacy issue, it's also important for national security. Programs that lack public support will not be politically sustainable in the long term.
The challenge is to do this without diminishing Section 702's effectiveness as an intelligence tool. Broadly speaking, there are three areas of opportunity. The first is to strengthen key institutions that oversee 702. This includes the FISA Court and the Privacy and Civil Liberties Oversight Board. The second area is greater transparency, so about how 702 affects Americans, about how agencies query 702 information, and about how the government uses 702 information in the criminal justice system. The third area is to strengthen accountability for those who receive signals intelligence reporting, to ensure that classified material is handled responsibly and never used for inappropriate purposes, including political purposes. I'd also like to mention one thing I hope this process will avoid. One of the 9/11 Commission's key messages was that intelligence agencies need to be able to connect the dots between various pieces of information they've collected. I worked for Tom Kane and Lee Hamilton back in 2004 during the process that led to the creation of the DNI and the NCTC, and I know that Congress and the intelligence community have moved heaven and earth since that time to break down information stovepipes in the IC. With a very grave terrorist threat still confronting us and our allies, it would be unfortunate to reverse course on that progress now. We should not create new obstacles that could prevent agencies from connecting the dots and stopping terrorist attacks. I'm happy to provide more detail on any of these points during the Q&A. Thank you, and I look forward to your questions.
Thank you very much, Ms. Gotine.
Chairman Grassley, Ranking Member Feinstein, and members of the committee, thank you for this opportunity to testify on behalf of the Brennan Center for Justice. Congress's goal when it passed the FISA Amendments Act in 2008 was to give our government more powerful tools against foreign threats. The government has used this authority to monitor suspected terrorists overseas, to trace their networks, and to interrupt their plots. That is exactly as it should be. We're here today because of the other things that Section 702 has been interpreted to allow. The government is not simply monitoring foreign terrorists or foreign powers. Instead, it's scanning the content of almost all of the international communications that flow into and out of the United States and acquiring hundreds of millions of communications each year, including a large, although still unknown, number of Americans' communications. In addition, despite being required to minimize the retention and use of Americans' data, the government keeps that data for years and routinely searches it for information to use against Americans in ordinary criminal cases. Indeed, current rules allow the FBI to read Americans' emails and listen to their phone calls without any factual predicate to suggest wrongdoing, let alone a warrant. I don't believe this is what Congress had in mind when it passed Section 702. But in writing the law, Congress entrusted the executive branch and the FISA court with significant discretion. For instance, Congress allowed the targeting of any foreigner overseas, trusting the government to focus its efforts on those who pose a threat to our interests. Congress also left it to the executive branch and the FISA court to fashion specific minimization rules. I don't mean to imply that this trust was misplaced. In fact, we've seen essentially no evidence of intentional misuse. But what we have seen is mission creep, so that a law designed to protect against foreign threats has become a major source of warrantless access to Americans' data and a tool for ordinary domestic law enforcement. This outcome is contrary not only to FISA's original intent, but to Americans' expectations and their trust that Congress will protect their privacy and their freedoms. There are several reforms that Congress could enact that would shore up protections for Americans while preserving the core of Section 702, the government's ability to collect the communications of suspected terrorists and others who wish us harm without a warrant, even when those communications transit through or are stored inside the United States. I'll touch on three of the key reforms here. First, Congress should narrow the scope of surveillance by requiring the government to have a reasonable belief that the target is someone worth targeting, such as a foreign power or a suspected terrorist. This would be an internal determination. There would be no probable cause showing, no FISA court approval. This reform would offer critical protection, not just to law-abiding foreigners, but to Americans. When the government can target any foreigner overseas, that enables a massive amount of collection of innocent conversations between Americans and their friends, relatives, and associates abroad. Those communications then sit in huge databases where they are vulnerable to data theft, hacking, negligent mishandling, and potentially abuse. This reform is also vital for the United States tech industry. The government's ability to target any foreigner overseas is one reason the European courts have invalidated data sharing agreements between U.S. and European companies. That's why 30 major U.S. tech companies, including Google, Microsoft, and Facebook, signed a letter urging Congress to limit the scope of Section 702 surveillance along with other reforms. Second, Congress should require the government to obtain a warrant before searching Section 702 data for Americans' communications. Contrary to what Mr. Evans said earlier, restrictions on searches of lawfully acquired digital information are the constitutional norm. Even when the government has a warrant to seize and search digital data in a criminal case, it cannot run a different search of that data for different reasons without obtaining another warrant. It certainly should not have that freedom when it obtained the data without a warrant, based on a promise that its only targets were foreigners. Third, Congress should codify the end of about collection. This practice has no basis in the statute and scant basis in the legislative history. It's a small part of upstream collection, which is itself a small part of Section 702 surveillance, yet the privacy concerns it raises are uniquely significant. This is clearly a case where the risks outweigh the benefits. These basic changes would not only go far toward protecting Americans' privacy, they would also better align the statute with the goals it's meant to serve. I'll stop there, and I look forward to taking your questions.
Ms. Collins.
Chairman Grassley, Ranking Member Feinstein, and members of the committee, thank you for the opportunity to testify today. I provide this testimony in my capacity as an individual board member of the Privacy and Civil Liberties Oversight Board, an independent executive branch agency charged with providing advice and oversight with respect to federal counterterrorism actions. From 2013 to 2014, our 5-member bipartisan board conducted an extensive examination of the 702 program. In July 2014, we issued a unanimous report concluding that the Section 702 program is valuable, statutorily authorized, and at its core, constitutional. We set forth the legislative foundation for the program, the implementing procedures that govern the operation of the program, and the extensive oversight structure that accompanies the program. We also unanimously voted out 10 policy-based recommendations, each of which has been implemented or is in the process of being implemented, and none of which required legislation. My oral and written testimony draw heavily from the board's report, which continues to be a valuable resource for understanding and assessing the program. The board conducted both a legal and policy analysis of the Section 702 program. We unanimously concluded that the program has a limited scope. It does not authorize or result in bulk collection. Instead, it authorizes the government only to engage in targeted collection of telephone and internet communications of non-U.S. persons located abroad who are likely to communicate information about court-approved foreign intelligence topics with the compelled assistance of providers. Although U.S. persons may not be and are not targeted, U.S. person information may be incidentally collected, and that aspect of the program was a core focus of our attention, leading to key recommendations on minimization procedures and transparency. We also weighed the value and the privacy implications of using U.S. person identifiers to query 702 data. These queries are consistent with years of direction to the intelligence community to connect the dots, but also raise significant privacy implications. And we made recommendations designed to address those implications. The board also focused on the judicially approved targeting and minimization procedures governing the operation of the program. We noted the special protections afforded to U.S. persons and made recommendations designed to tighten certain aspects of the procedures. Finally, we considered the extensive and layered oversight that accompanies the 702 program. Oversight occurs in all 3 branches of government and can only be described as rigorous. Although we identified no instances of deliberate abuse, there is always the possibility of human or technological error, as with any complex program, and robust oversight is essential. As a legal matter, we unanimously concluded that the program is statutorily authorized and that the program is constitutional, although certain features of the program push it close to the limits of Fourth Amendment reasonableness. Specifically, we raised and addressed concerns about incidental U.S. person collection, so-called abouts collection, and the use of U.S. person identifiers as query terms. The board also spent significant time understanding the value of Section 702. It has helped the United States learn more about the membership, leadership structure, priorities, tactics, and plans of international terrorist organizations. It has enabled the discovery of previously unknown terrorist operatives, as well as the locations and movements of suspects already known to the government. It has led to the discovery of previously unknown terrorist plots directed against the United States and foreign countries, enabling the disruption of those plots. Overall, we came to appreciate the flexibility that Section 702 affords the executive branch while still within the framework of judicial approval and oversight. The board's report and recommendations are consistent with what has been called a clean reauthorization of Section 702. We made serious recommendations, each of which we thought necessary to enhance privacy and civil liberties protections, but none of which required legislation. Each of these recommendations has been or is being implemented. I personally view Section 702 as a valuable tool in the fight against terrorism and believe the current framework for Section 702 provides the necessary protections to ensure that our American values are not compromised. I look forward to answering your questions.
Let me start with a question for all of you, and to some extent, each of you, or maybe I shouldn't say each of you, but some of you touched on this. You heard me mention earlier some suggesting that the government should have to get judicial approval or even a warrant before searching lawfully collected 702 information using U.S. person information. You all come from different perspectives, and you all have different backgrounds. I'd like each of you to answer the question, is there any legal or constitutional reason why we should require judicial approval of a warrant before Section 702 collection can be searched using U.S. persons information?
Thank you, Mr. Chairman. First, on the question of legal or constitutional requirement, I think the answer is no. Judge Hogan of the FISA court addressed this issue head on, the question of whether or not to require a warrant for searching Section 702, and determined that it was consistent both with the FISA statute as well as the Fourth Amendment to permit the FBI to conduct such searches without going to a court in the first instance to obtain a warrant or for any other judicial approval. I would add that I think it's operationally extremely unwise to impose such a requirement, and I would point as a hypothetical example to the Zazi case, which the committee is aware of. Zazi was the individual in Colorado who was in touch with an al-Qaeda courier in Pakistan. And the hypothetical I would pose is, imagine if the information about Zazi came from a tip. Somebody said to the FBI, this person Zazi is in the midst of plotting to carry out an attack on the New York subway. That would not constitute probable cause in all likelihood, and the FBI would therefore be barred from checking its own databases to see if a communication existed between Zazi and this al-Qaeda courier in Pakistan. That's the first thing that we want the FBI to do when they receive that information. It's an unintrusive or a relatively unintrusive step, and it allows the FBI then to determine what else they need to do, and I would suggest that imposing a judicial requirement would bar that information from the FBI being able to access it.
Mr. Klein.
This is certainly not a trivial privacy question. That said, I agree entirely with Mr. Olson's analysis of that. One point I'd like to add is we now have some information in the public domain about the scale of this problem, how much foreign intelligence information is coming through this channel into the criminal justice process. And we know from the most recent IC Statistical Transparency Report that there was only one case in 2016 where an FBI agent actually pulled up 702 information in a U.S. person query in an ordinary criminal case. So given that the scale of this is very limited, I think it would be a significant overcorrection with major consequences for national security potentially if we were to impose a court order requirement. There are other ways to get at this problem. It is not a trivial privacy question. We can have more transparency about why these queries are necessary. We can have more information precisely about how often the Bureau does them and how often they return information. And we've proposed a possible slight narrowing of these queries in some cases in my written testimony. But by and large, I think that the current practices need to continue.
Ms. Gotine.
We're talking about this information as if it somehow landed magically in the government's databases. The way the government got this information without acquiring a warrant in the first instance, even though it knows it will be pulling in Americans' communications incidentally, is by promising the FISA court, by certifying that its only interest is in the foreign targets, that it has no intention, no interest in any particular known Americans. If it instead went to the FISA court and said, there are particular known Americans whose communications we are hoping to read as a result of this collection, then the government would have to get a warrant. So to me, warrantless backdoor searches are a violation of the spirit, if not the letter, of the reverse targeting prohibition. I will also say, as a constitutional matter, this has only quite recently been looked at by any courts outside of the FISA court. But the notion that once data is seized, the Fourth Amendment is done, and the Fourth Amendment doesn't apply to any later searches is actually not correct. You can tell by analogies to criminal cases in which data may be seized under a warrant, but if the government wants to conduct a separate search later for different reasons, it actually does have to go get another warrant, even though it's already collected the data and it's sitting lawfully in the government's databases. And I can provide that case law.
Ms. Collins.
Based on the board's analysis, I do not believe prior judicial review for a U.S. person query is constitutionally required or advisable as a policy matter. We spent a tremendous amount of time on the issue of U.S. person queries, and we made a number of recommendations designed to enhance privacy protections. These recommendations, which have been implemented, impacted the NSA, the CIA, and the FBI. But after extensive discussion and consideration, the majority of the board declined, even in the most difficult case, which is the instance of a query by an FBI agent in an ordinary case, to recommend a warrant requirement. We were concerned that such a requirement would raise the threat of rebuilding the so-called wall between intelligence and criminal investigations, and that criminal investigators needed to be aware of potentially relevant 702 information. We did, however, recommend additional restrictions on the use and dissemination of any such queried information.
Senator Blumenthal, should I call on Senator Lee while you're getting ready, or are you ready? Okay, go ahead.
First of all, regarding the FISA court and the Amici briefs and the role that they play, I have long been concerned about ensuring that the FISA court, which authorizes and oversees government foreign surveillance activities under Section 702, as you know, and other authorities, has sufficient information about the civil liberties and privacy implications of the decisions that it makes. In 2013, I proposed legislation to establish a special advocate to assist the court in that task. And I think it's fundamental that the FISA court hear different perspectives and legal reasoning about the weighty statutory and constitutional concerns involved in this area. In 2015, Congress, as you know, passed the USA Freedom Act, which created an institutional process for participation of amicus curiae to provide the FISA court with information about civil liberties and privacy concerns when the court is presented with novel or significant questions of law. The court has I understand, appointed 5 amici to fill this purpose. So my question is, do you think they have played a helpful role? How could this process be improved? And what do you think are the next steps for FISA court reforms in regard to bringing these different perspectives to bear? And that's for the whole panel.
Thank you, Senator. This is something I've written about. I agree with you entirely that the amicus development is a good thing. I work in this space, so I read the declassified FISA court opinions. I read the U.S. Court's transparency reports, so I know that the FISA court is doing rigorous oversight. But if you talk to ordinary people, if you talk to law students, they're skeptical. And there are 2 reasons. Because it's in secret, and that really can't change by and large, although the declassified opinions are a good thing. And the other reason is because in most cases, only the government gets to argue. And people are used to a court where both sides get to argue. And so the USA Freedom Act adding the amicus was a good thing. People are heartened to know that. But as we know, it's in the court's discretion. It's not mandatory. And so given the significance of the annual 702 recertification proceeding, one thing that I've proposed that I think would help strengthen the public confidence that that is very rigorous oversight is to require the court to appoint an amicus just in that one category of proceedings, which is programmatic oversight and thus is exceptionally high stakes. This is a way to build trust in 702 that people know that it's getting rigorous scrutiny, and it wouldn't affect the government's implementation of the program, which is what we're all concerned about one bit.
Thank you. Yes.
Senator Blumenthal, first I want to thank you for your leadership on that issue specifically. I think that was an extremely important contribution of the USA Freedom Act. I think it's very clear from the act that Congress intended for the FISA court to make use of amici in really any case in which there was a novel or significant legal issue, unless there were some extraordinary circumstances. I think for the most part, the court has done that. There have been a couple of occasions on which the court has found participation inappropriate based on the rationale that the court just didn't need help. I don't think that's really consistent with what was intended, but that's been rare. But that's something I think this committee should keep an eye on. I do think it makes sense to have participation in the annual certification process be mandatory. And the one other thing I would suggest is that there's currently no provision for amici to appeal rulings of the FISA court if the amici's arguments were rejected. And sometimes that's important. I think we saw in the FISA court's decision on backdoor searches, there were a number of, to say the least, very novel legal issues there that would have benefited from review. So I think Congress could usefully add a provision requiring automatic certification to the FISA Court of Review in significant cases where the amici's arguments are rejected.
Thank you. The Privacy and Civil Liberties Oversight Board spent a significant amount of time looking at the workings of the FISC, and we addressed the Foreign Intelligence Surveillance Court both in our 702 report, which is the subject of today's hearing, and our Section 215 report. And we made a series of recommendations which were designed primarily to enhance public confidence in the workings of the FISC and the oversight that that body provides. We supported the concept of a special advocate. It was one of our recommendations. We did ultimately leave it to the discretion of the Article 3 judges who sit on that court. But to Ms. Gotein's point, we did also recommend consideration of a mechanism for appeal, although not as of right.
As you know, my initial proposal was for a special advocate, and that it be, in fact, at the advocate's discretion whether to be engaged, not at the court's discretion. So I would welcome thoughts as to how to improve the present process. Did you have any comments, Mr. Olson? I didn't mean to interrupt.
No, that's all right. And I would simply add, as somebody who has appeared many times before the FISA court on behalf of the government, that the characterization of the court as a rubber stamp or insufficiently cognizant of the array of issues before it, I think, has been unfair. That said, I agree with the benefits from a public legitimacy standpoint of including the opportunity for these judges to appoint amici in appropriate cases. So I largely agree with my colleagues here in how that's worked out over the past couple of years.
And we all know that the best judges, who are not rubber stamps, welcome the advocacy, strong and vigorous advocacy on both sides of an issue, because it enables them to make better decisions. Their worst nightmare, in fact, is a defendant who is unrepresented or representing himself in many respects. So
I agree.
That's the way the system works best. That's the spirit that led me to make this proposal. Thank you all very, very much. Thank you, Mr. Chairman.
Senator Lee.
Thank you very
When
much.
Senator Lee's done, I'll just have one question, and then I think we'll be done. Go ahead.
Ms. Goitein, I'd like to start with you. Why is it concerning if agents decide not to use information that they obtain when doing a backdoor search? In other words,
I'm sorry.
what kinds of concerns does it raise when you've got somebody doing a backdoor search, whether they use it or not? Why is that a problem?
Oh, I see your point. Well, I think the point is that the search itself is a violation of Americans' privacy. That's the heart of the Fourth Amendment, is that the government has to have a warrant before intruding on an American's reasonable expectation of privacy. And whether or not they find something as a result of that does not affect the privacy intrusion. It has other effects, potentially. But, you know, if the government enters your house without a warrant and doesn't find anything, there's no argument there that somehow your privacy wasn't invaded because the search was fruitless. So I think we have to understand the nature of the privacy intrusion when the government is allowed to search Americans' communications without a warrant.
Okay.
What kinds of things can information be used for? What kinds of investigations could incorporate information obtained through a backdoor search?
Well, we don't know exactly for a couple of reasons. One reason is because the list of crimes unrelated to national security that the Department of Justice is authorized to use Section 702 data when prosecuting, that list is not public. All we know is that it's serious crimes, but we don't know which crimes those are, and despite repeated requests, that information has not been made public. The other reason we don't know is because the government has had spotty compliance at best with the statutory requirement that it notify criminal defendants when using evidence obtained or derived from Section 702. The government's interpretation of derived from appears to be quite generous, perhaps creative, but once again, the department has refused to make that interpretation public. It's fighting FOIA requests for that interpretation tooth and nail. What we do know is that there were no notifications given at all until 2013, and then when the government was essentially caught telling the Supreme Court that it notifies defendants when it doesn't, it changed its practices. Since then, I think there have been 8 cases in which there were notifications, despite the fact that the FBI routinely searches Section 702 data certainly in national security cases, and there have been hundreds of national security prosecutions during this time. So we have an information deficit here.
And in fact, we don't really know. We don't really have any idea how often this occurs. And you know, your organization recently signed a letter to the Director of National Intelligence expressing dismay as to why he was choosing not to provide an estimate as to the number of Americans who are subject to these.
Yes, and if I could, I would like very much to speak to the notion that this is somehow infeasible, or at least not without drastically violating Americans' privacy. There are 3 kinds of collection under 702. The first is collection of telephone calls. It is a simple matter to assess, to estimate whether someone on one end of the call is an American, and that's by looking at the country code. It's not perfect, but we're not looking for perfection. We're not looking for an exact count. We're looking for an estimate. It is certainly sufficient for that purpose and involves no privacy intrusion. The second kind of collection is upstream internet collection. When the government conducts this kind of collection, it must first run a filter to try to filter out wholly domestic communications. It doesn't do this by doing a lot of research that invades Americans' privacy. It does this using IP addresses and some comparable technical means. That's what the PCLAB reported. And in doing so, it manages to filter out enough domestic communications that it can comply with the Constitution. So if this method of determining the American versus foreign status of a communicant is sufficient for purposes of complying with the Constitution, I think it should be sufficient for purposes of giving Americans a rough sense of how many of their communications are collected.
Sure.
The third program is where there are more complicated issues. But even for that program, the privacy community is unanimous in saying that conducting a one-time limited sampling under careful conditions would be a net privacy gain.
Oh, thank you. And by the way, Mr. Chairman, I'd like to submit that that letter that I referenced a moment ago for the record. As the letter notes, Senator Wyden has been requesting this information since 2011. The House Judiciary Committee and privacy groups have been requesting that information now for nearly 2 years. And members of the House of Representatives were promised, I believe, by Director Clapper and Director Coates that the estimate would be forthcoming. So we have yet to receive that information. And it sounds like you certainly share my concern with the fact that notwithstanding those assurances and notwithstanding the public interest in this, there's no information yet.
There's no information, but there was a lot of progress. Under the previous administration, there were several meetings that the intelligence community had with House members, with members of civil society, in which they discussed methodologies they were considering. There was a tremendous amount of progress on this, and the letter from members of the House Judiciary Committee confirmed their understanding that the administration had committed to providing that number in early 2017, hopefully by January. And in fact, all accounts, public and private, suggest that they were on the verge of launching that count towards the end of last year. We've had a change of administration, and the government has now backed off of its commitment to provide that information.
Thank you very much. Thank you, Mr. Chairman.
Said I just have one question. It'll be for Ms. Collins. I believe that transparency in government leads to increased accountability. I suppose all of you believe that too. One of your board's recommendations was to provide additional transparency surrounding how often NSA obtains and uses incidentally collected communication of our citizens. I also understand that in February 2016, the board described the recommendations as being implemented. So this is the question. The board's last report on this was about a year and a half ago. So can you walk us through the specifics of the 5 things the board recommended in this area and provide us an update regarding the status of implementation by the executive branch?
When we did our report on Section 702, we spent a lot of time on the issue of incidental U.S. person collection because it has both policy and constitutional implications. And we ultimately did identify 5 measures designed to provide insight into incidental collection. And these are collectively reflected in Recommendation 9 of our report. And it has been partially implemented. And without getting into too many details, I can address this in further detail tomorrow in the classified briefing. To Ms. Gotein's point, the recommendation aspects that involve telephone data are easier to implement. It's just more feasible. I am sympathetic to the arguments of the DNI and the NSA that there are operational hurdles, there are technological hurdles to providing some of the information that has been requested. I'm sympathetic that there are certain methodologies that have been suggested that would increase privacy concerns. But I would add my voice to those who urge the DNI and the NSA to continue to find a way to provide some quantification or some estimate of incidental U.S. person collection.
Okay. I want to thank all of you for your participation, and thank you for the audience and all the staff that participated. We'll proceed someplace along the line. Thank you very much.